I don't care. Friends don't act this way. She called the police.
Yeah, she dropped the charge.
I don't care. She called the police.
Yeah,
You, unless she lied to the police,
Mhm.
and then we'll bring her up here. And then that's a crime. I want to know. She apparently was not lying when you acted the way you did this night, not only spitting on the officer, but pulling a knife on your friend and attempting to force entry into her residence by kicking the door in. Don't have any contact. She's going to be a witness in this case. That supersedes any
Even if she
attempt to try to change her story.
I was in a county on both the charges.
I don't care. You're under my jurisdiction right now.
Yes.
You're going to follow the rules and not act foolish. You're going to have a GPS device so I know where you are, have no contact with this witness, and no contact with the officer as well. Do you understand? That's a yes?
Sir.
Okay, nodding doesn't get it on the record. You have to speak. That's the way we communicate. You understand?
Yes, sir.
Your problem is you're not following the rules. You're looking at up to 10 years in prison. Does that bother you? Does that worry you at all?
Yes.
It should. It should. All right, what's my next event? Announcement?
Yes, sir.
You have 48 hours. What's the relationship? Langston? What is it?
Oh,
Was a police officer?
it's a police officer. This is
Harassment of a public
harassment
servant.
service. It's the
It
police.
says the complainant additionally advised that
The lady and
that was attempting to force entry into her residence by kicking the door in.
she's not complaining at all. I think police officer saying he was spit.
Upon arrival, officers observed the complainant, Caden Branch,
Well, it was no
and Charlo in the front door. I mean, this probable cause talks about a complainant.
right, but I'm
Branch said that Charlo pulled a knife on her and wanted him removed for her property.
right, but
Then officers were investigating and he becomes uncooperative and begins to walk backwards. Officers grabbed a hold of him. He began to physically arrest. Then he was handcuffed and let's see, turned in the direction of officer and spat on her while a search was going to be conducted in front of the police vehicle. He caused someone he knew to be a public servant to come in contact with saliva while the public servant was lawfully discharging an official duty. Also, apparently the defendant grabbed Caden Branch by the shirt and tried to kill her while having a knife in his hand. Branch advised that he had left the residence, but he returned shortly after, and that's when he kicked the door in and police were contacted. Branch wanted to pursue criminal charges. Charlo was placed under arrest for assault, family violence with deadly weapon, and harassment of a public servant.
Judge, I'm not sure why
Yeah.
I don't have the ag assault case. I only have the harassment of a public servant.
I'm over here for the harassment.
Okay. Today, what is this for
This
today?
is our first sitting, Judge. We want to put it on the announcement.
Okay. Couple of things. Orders are going to be entered to have no contact, nor anyone on your behalf contact the complainant who is the officer, nor the person Miss Branch, the person that the police came out to investigate you and your bizarre behavior that day. And you're going to have a GPS device, so I know where you are. So if you get any contact with her, I'll know about it and place you in jail. And that's where you will stay.
Can I say something?
Go ahead.
Me and her are actually still friends.
No. Friends don't act this way.
No, like we kind of like stay together.
Get the GPS device. And those are the orders of the court. That is all. Quarterly Cornish.
I started up.
No, I'm here. Just take mine. We'll bring it back when you're done. But hey.
Corey
that's
Cornish.
nothing forward at. I'm sorry. Okay.
Is this an initial? No, it's an announcement.
This is an announcement. We did do discovery on this case
Yeah.
and in the state's offer.
Ooh, God, dog, it's 2 years old, almost.
Right. And we looked at police reports. Ms. Cornish is informing me that she's absolutely innocent.
Yes, Your Honor.
That's what the presumption is all about. Well, I tell you,
That's it.
if I could just get a case here where extreme intoxication wasn't part of the actions, I jump off a cliff because that's what this is over and over again. Everybody's intoxicated. And here's my favorite thing. You're driving a car. Y'all are both intoxicated and in a vehicle, a 4,000-pound missile. Great. Yeah, I know you're smiling, but you know what?
I'm not
You know what we
smiling.
deal with in here? People who have been struck and killed by fatal incidents by drunk drivers. And there's no laughing. It's all a bunch of crying and sobbing and people begging to get their loved ones brought back. You ought to just sit in here and watch that. You wouldn't smile. Cornish wrecked. So you wrecked the car, her car, and not wrecked it into any other kind of vehicle, but into a patrol unit. Inviter, which the unit was working erect, and you were obviously so inebriated you didn't know what you were doing.
Oh, you're in there. I have a lot.
The complainant says you drove her car without permission and wished to file charges, and she got her wish. Here we are. Here's my favorite thing. I'm going to look into whether you've had any contact with this person. If you do, you'll sit it out in jail. You cannot contact a witness while this is pending. And these facts, I mean, I do this for a long time. You look too confident about all of this because you think you've already worked it out on the side. We all know that because we see it attempted all the time here. What happens is all it does is bring more charges to you. And the court's not going to allow that. I'll order the people to show up and we'll have a trial and they'll testify under oath and they can either tell the truth or they can lie and then they get it done. But here, a very serious event occurred and we're lucky people weren't killed because of reckless behavior. Not only driving someone else's car unauthorized, but slamming into a police vehicle that was investigating some kind of other incident on the road. All right, we'll set this for trial. They'll get ready. And by the way, a jury doesn't give deferred. If you're found guilty and even if you're given probation, it's a conviction for the rest of your life.
Yes, Your Honor.
Christopher Price?
He's here.
Christopher Price, what are we doing?
This is our first appearance, initial set with him. It's the first time we I did get discovery.
Okay, what do we, you're charged with state jail felony?
Yes, sir.
Oh boy, solicitation of prostitution, that's never a good one. It carries with it up to 2 years in the state jail. I don't see a prior conviction here. A prior conviction, you've never been convicted before. Fix this.
Yes, sir.
No, hey, work with him, who knows? What are we gonna do today?
Just the plan is I was gonna send a letter to Mr. Canard asking for pretrial diversion and see what he says. And in the meantime, just put it on announcement.
Okay, I'm sending an announcement, okay. Mario, just getting, resetting it. Mario Senegal,
The Senegal, she's here.
state, okay, that's you, Ms. Senegal, come on up.
Same thing with her, Judge. This is
I don't see any prior convictions here either, huh?
correct. And this
You've
is
never
what-
been convicted before, okay, fix this, fix it.
I can ask for the same thing for her. And this is her first sitting
Done.
for you as well.
Again, like the man before you, you're charged with a state jail felony, which carries with it up to 2 years in the state jail, but it's a felony. If you're convicted of a felony, it's with you like a horse riding on your back for the rest of your life. Closes off doors of opportunity, and it prevents you from enjoying some blessings of liberty because that conviction follows you forever. Fix it.
Yes, sir.
He knows how. All right, it's reset as well for an announcement. Ashley Stevens was reset.
Ashley Stevens is reset.
Yes.
He was arrested last night, so currently was just
Sorry.
run in the rain for.
Sean Thomas.
He's here. I think you had set this one for a special. I don't know, it was a special.
I don't know.
And
Oh,
I think I know.
oh, I know. He's testing positive for cocaine.
Yes, sir. I just talked to Johnny today and
Positive for
she
cocaine.
told me that my.
Hold on. Positive for cocaine. Positive for cocaine. Positive for cocaine 5 different times. Where are you getting it from?
Sir, it's my barber. When my barber had to cut my hair,
Say that again?
my barber, he do my hair.
Yeah.
I guess he has it on his hand.
Oh, he has it on his hands. How long you been working on that one? It's a mystical event here.
Oh, sir.
We've got you really think that hadn't been tried before? And if that worked, don't you think everybody would pull that one? Oh, I get it from my barber. Who is your barber that has cocaine? What's his name?
His name's Stephen.
What's his last name? It's your barber. What's his name?
Stephen Giles.
Okay. So where's he getting the cocaine from if it's coming from him? Do you know?
No, sir.
Well, how do you know he's got the cocaine?
I just seen.
You just first name you could think of to blame?
I see it on his hand. I seen it on his hands the last time.
How do you know that was cocaine and not other powder?
I just seen like white residue.
Oh, okay, it's powder. They use that at a barber
I
shop.
know I don't do it, so.
Okay, well, they use that at a barber shop. Generally, they don't use
But
cocaine.
It's not a professional barber.
Okay, I don't care what it is. They still use powder. I mean, that's what it normally is. But hey, you chose the guy.
Yeah.
You chose the guy. Hey, you've been testing positive since. Let's see. All right. About every 2 weeks, you're testing positive. How often are you going to the barber? You're going to the barber every 2 weeks?
Yes, sir.
Yeah. Okay. Nonetheless, this is all.
I talked to Giants too the last time, and she said it might my
What's his bond right now?
You heard me, sir?
I heard you. Did you hear me?
Yes.
What's his bond?
I'm looking.
You don't run things here. You're charged with a serious crime. You're looking at 2 years in prison And you've tested 5 times for felony offenses. You might want to stay quiet.
$20,000.
That's not enough. It's $100,000. Plus you have to have a drug patch, 24 hours. That's right. That's how we're testing it. Well, the drug patch is not working. Next positive drug, you're revoked. But you've got 100,000 now. Taken into custody until you can make that.
It's $100,000.
It's $100,000. And the next positive will be no bond. We'll work with you here to try to get you off your problem. What are we gonna do next? What are we gonna do next?
Oh, I guess at this point, we can put on an announcement. I can get with him to see, because now what he did tell me, and maybe this might be somewhat of help
Yeah.
to him,
Go ahead.
is that if you look at the date of the last test, it says 5/29/26.
Yeah.
And he told, and to my understanding, is that on May I want to say you said 14th, on May the 14th or 15th, somewhere on there, is when he had his prior, test for being positive. And when you take this test on the 29th, that's still within that 14-day window, and the cocaine doesn't leave
It's not,
you.
it's a 15-day wait. You just
Well, I'm sorry.
14,
14.
29 is 15
Well,
days.
14. I'm trying to stay within. It's
I know, but
it's within that time period.
no science has ever shown that. I mean, it's about a 2-week window.
Yeah,
But nonetheless, this is spanned over
right.
how many months? 3? Come on. Cocaine moves out of your system fast. We all know that. That's what it's called speed. All right,
But those
the
leaders
orders on the board.
on-
That is all. Thank you. Hey, Langston, on,
Which one?
you got, is that it? You don't have,
I think that's
okay, all right.
That's it.
Edwin Jones? What are you doing, Dustin, on Benjamin Figueroa?
Well, Judge, it's my understanding, we're just here for review. My understanding, he's still doing great. I asked the probation officer and she said he's had no issues since the last time we were here. This is one we have been present for a long time because he had for restitution. He's paid that all at all. But there's a new case coming and that's what we've been waiting on as well. So it's kind of holding.
What are we supposed, it says a hearing. What are we supposed to do?
I don't think we're really set up hearing. We've been here several times. What's it going? But Judge, I believe,
Revoke probation filed, right?
yeah, but I believe Mr. Coleman took the case over.
Why are we having a motion to revoke probation hearing anytime?
Well, one reason, Judge, is because they have not received the new DWI. But the other reason was because there was a large amount of restitution and the court reset this several times for him to make payments and he paid all of that off. And so there's kind of two things going on, but we still don't have the new case and he has paid all the restitution on it.
Okay, this was filed back in September of last year. This is too long for a motion. We're going to move forward without the driving. If whatever we're waiting on the DWI, forget it. I've got 3 other violations set for hearing. When can y'all be ready?
A couple weeks, Judge. I know that Mr.
2
Coleman is
weeks.
appointed to it.
Huh?
I know Mr. Coleman just recently received it. He's not familiar with it.
weeks to get ready.
So 2 weeks, what's 2 weeks from right now?
July.
14 days.
Yeah.
Yes. Okay, and get a resetting, 2 weeks for hearing. Edwin Jones, where's Mr. Jones? That's you. Wait. Where's Benjamin Figueroa?
He's right there on the back row.
Okay, he needs to come up and get a resetting. Okay, Thomas Burbank is where is he?
I think he's in trial next door. Huh?
I saw him walking in the drug impact court when I drove in.
He had to go to drug impact for this morning and then.
He's in trial next door?
Yes.
So what were we supposed to do today? Did he leave an announcement or anything?
Not with me, Judge. Just.
Good Lord. It's 5 years old. I was a teenager when this thing was filed. Almost. That's correct. This is. Good Lord. No. Good grief. Set for trial. Put it on trial docket as soon as possible. We need relief here, all of us.
Yes, sir.
You know, I don't see any prior convictions. Have you ever have been convicted of anything?
No, sir, I don't get in trouble.
Tell me how you really feel, Jim.
You don't want to know.
Yes, sir.
Deep for this.
Oh, yeah.
Hello.
Are we almost out of them?
No, I'm gonna tell my office to get these.
Yeah, the question.
I keep this on my, I like.
Yeah, the people. Well, good one. Well, I have, because I have to keep, oh, yeah.
He gives Mountain Dew, and it's.
But now he put some money down.
Yeah, but he puts money in, so I give it to him to keep us in stock.
I'm not. I'll have to pay for it after I get my 10th one.
All right.
Couple of the police officers spoke about how you go to church with like American Gallery. Did they like bro? About something with your lawyer this morning. No, not telling you for that, but they're gonna keep watching. But they spoke highly about before they investigated this. Don't like really. It's awesome.
What are we doing? I got a dismissal and that's 2263.
That's the.
2263 is what we picked the jury on, Judge. The other matters, these other pending
So
cases.
what are we doing?
Or
What are we gonna do?
pleading guilty, the term is 10 years, probated for 10 years. Condition of that is he's gonna do the batter's treatment program.
And I also have an increment class up here as well.
So 232263 is called the State of Texas versus Andrew Lee Lakey with his attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and arraignment? Can we proceed to summary?
Yes.
In summary, this states that on or about November 16th, 2023 in Jefferson County, Texas, you committed a third-degree felony of assault by choking. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
Agreement's been reached. Where you would be pleading guilty, found guilty of this crime, sentenced to 10 years in prison. That would be suspended. You would be placed on regular probation for 10 years, fined $500. There would be terms and conditions of probation, which are normal and customary for this type of offense. Is that your understanding?
Yes, sir.
What's going to happen? If I follow this, you have no right of appeal. Hey, we need another device like this, because this is not working on this pad. I can't erase this thing.
No, Judge, I don't have.
I can't,
anything, but-
there's something on the pad. Okay, you won't believe this. It now just disappeared. This thing. Okay, if I follow this agreement, which I'm going to do, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Show you what the marked states exhibit one. Did you sign that? Understand it? Discuss it with your attorney, or the contents all true and correct?
Yes, sir.
States exhibit one is tendered into evidence.
Without objection.
Without objection, it's submitted. It states that you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with, and indictments will refer to you. You were guilty of the crime charged. Any lesser included offenses you're giving of your rights to your jury trial. No right to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer, all true. The state so help you God. The state's exhibit one is part of the record for all purposes. Pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement if nothing further and find you are mentally competent to enter your guilty plea. It is freely and voluntarily made. There is sufficient evidence supporting your guilty plea from state's exhibit one here to find you guilty beyond a reasonable doubt of this third-degree felony of assault of family violence by choking. I now find you guilty beyond a reasonable doubt. I am following this agreement. You're hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. That is going to be suspended, and you will be placed on regular probation for 10 years. You must pay fine here. There will be fine of $500. There will be terms and conditions of probation, which include completing a batterer's intervention program and paying those costs, entering in successfully plea and anger management program, and other conditions of probation. Most of these conditions of probation, you've heard this before, of things we all have to follow. All of us. Do you understand what has happened today, sir?
Yes, sir.
Is there another case that's
Yes, sir. And it's
dismissed?
correct, Judge. You should have that in your queue.
All right, I will be signing that. Please see the probation officer. Please.
Mhm.
We did, yes, it's Somerset this morning. Do you know
Let's set it for trial. Jones.
Bring the jury in. Kendall, thanks.
Yeah.
Do I need to bring him in, or can I go up and talk with him?
You can go up. I'm sorry, Judge, that wasn't a question for me.
Do we need to give him anything, or where do
I
I?
think you go off to the district clerk's office.
Okay, here.
You too.
That's what I got in here, and Ms. Gonzalez. You're not, are you?
From my understanding, Judge, last time I saw that the defendant was in court, there was some information revealed about contact with the victim. And so Ms. Gonzalez may have filed a motion to increase his bond based on his contact with the victim.
Hereby alleges defendants violated conditions of bond, specifically not having communication directly or indirectly with the complainant victim of the pending case, nor going near any residence, school, job site, or other location. State has reason to believe the defendant has violated these conditions. He appeared with counsel in front of the court on June 16th and stated he had not had any contact with On the same day, victim's mother called the district attorney to report he has in fact made repeated communications to her and her daughter, the victim, and stated he would take them to court to get custody if he was not allowed to see his daughter, the victim. The state contacted the victim's mother again on June 23rd and was informed he has been to the house where victim and her mother lived multiple times and told them that he did not have a bond condition where he was not allowed to speak with them. Additionally, the victim's mother states he has called her multiple times wanting to see his daughter, the victim. Whereas state praise that the bond amount be increased. That's what they're asking for.
Your Honor, if I may, in discussing with Mr. Rodriguez, he wants to obviously comply with all the conditions that are required of him.
It's not that he wants to.
Well,
He doesn't have a choice to, or else he goes to jail.
what I mean is he's not intentionally violating a court's order. If I may, Your Honor, when he was arraigned by Judge DeRuan, these were the conditions and terms of the order that the court will notice. These boxes were not checked when he was arraigned by Judge DeRuan.
Hold on.
You have that in your, this is what I'm referring to.
See what's in the court's file.
No,
She was only built by him.
the two boxes that aren't checked.
Hold on, wait, what does state know about this? You just kind of picked it up, didn't you?
Yes, sir. I did speak with Ms. Gonzalez before she left, so I knew that the victim had made a call to our office letting us know. And based on the documentation that defense counsel has, it says no communication in a threatening or harassing manner. And based on the report from the victim, his communication was in a threatening or harassing manner.
If I may, he has been served with a protective order on June 25th. Down in the out of the 317. So there is a protective order in place now. It's set for a hearing, July 9th.
There was a protective order ordered and signed to be filed December 16th of 25.
He was never served. He didn't have any notice of it. Now I can elicit that from him under oath, Your Honor. Under penalty of perjury.
Yeah, go ahead.
You
I wanna know.
Swearing?
Yeah. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Lower your hand. Go ahead, give it your best shot.
Well, it's.
Go ahead.
As far as.
No, go ahead, ask him the
The
questions.
protective order that the court has indicated that it was entered on December, what was the date, Your Honor? December 16th?
Stand by. 15th.
15th. When you started with that, or did you sign anything indicating you had received it? Did you know about it?
No, sir. The only thing that I got served on was the child support, and this one that I just got served last week.
And you say this one you're pointing to the
The one that I got a hearing for this week on the 9th.
July 9th and the 3/17th, is that correct?
Correct.
I think that's. I'm sorry, calls when you are here. That's clause number 26, DCF M 0782, the detective ones.
Yes, sir.
And you were served that on July 9th, I'm sorry, June 25th, is that correct?
Last week.
And that's set for hearing July 9th. When you were magistrated, given your magisterial warnings by Judge DeRuin back on, what was the date of that? March 12th of 2026. Were you advised that you could communicate with a person protected by the order or a member of the family, that you could communicate with them as long as the communication was not a threat?
Correct. I personally asked him and he told me.
Threatening or harassing manner, is that right?
Yes, sir. I personally asked him again after he gave me the paperwork and he said that I was able to see my little girl.
Just the reigning magistrate.
Yes, sir. I don't know his name, but yeah.
Okay. Now, when you bonded out, did the bondsman present you with paperwork that indicated you were to have no contact?
They did, and I brought this to their awareness and
You
they.
say this, you mean the order signed by Judge DeRuin?
Yes, sir. I brought that to their awareness and they said that they were going off of what he said.
What the magistrate, what the judge had said, not
Yes,
what
sir.
they were saying, is that right?
Correct.
The bondsman. And based upon that understanding, did you have, you had communications with them, with him?
My little girl.
Okay, you had communications with her?
Yes, sir.
What about the alleged victim, your wife?
Well, that's how I was getting in contact with through her. And whenever child support, I had a hearing with them. They said that they're going to wait for your date of court to come in order for them to give me the rules on what they agreed to. They said they were going to go with what Judge Stevens said,
Talking about CPS or child support?
the child support. So I have a court with them this month as well too. They wanted to see what Judge Stevens was going to say.
When we were in court in front of the judge, Judge Stevens personally told you not to have any contact, is that right? What date do you recall the date?
I think it was the 16th of this month that just passed.
June,
Correct.
June 16th. Since June 16th, have you abided by the court's directive to you not to have any contact?
Haven't had no contact with them ever since.
My passwords.
I have no questions for this witness, Judge.
So let me see your driver's license, please.
Your Honor, obtaining a court, defendant's driver's license.
Thank you. What we got here is just some confusion. Here's the magistrate's order for the emergency protection that was ordered by Judge DeRuin on December 16th, 2025. You never got a copy of this?
That's my copy right here.
Let me see. You never,
I got it out of order.
actually, did you sign this document that states you understand what your obligations were? Yeah, there you go. That's your signature.
It's the same, you know.
It's in blue ink. So, you acknowledged on some date, this generally states signed December 16th, but maybe, 25, maybe you did, or did not on that date, but nonetheless, you signed this order acknowledging receipt of this order, and in this order, it states the court hereby orders you to uh, refrain not to do the following things. You shall not commit family violence against a person protected in this order. Communicating directly with a person protected by this order, or a member of the family protected by this order in a threatening or harassing manner. Communicating a threat to any person to a person protected by this order. Going within 100 yards of the residence or place of employment of the business of the person protected by this order. The persons protected by this order are Marissa Cruz, who is yeah. Are y'all still married?
No, sir.
Y'all when were you divorced?
Well, we never were married, huh?
You weren't even common law married?
Common law is if you live together a certain amount of time.
And hold yourself out as married.
But yes, sir. Yes, Your Honor.
And then Rosaura Rodriguez is your daughter. Okay, those are the two people who are protected by this order. So what changed subsequent to this? Because this order is in effect and by the judge. And
I think it expired in March, Your Honor, if you look at the paperwork.
oh,
There's an expiration. I was perusing it. I noticed that I believe it's expired in March 12th or something. It's in there.
I don't see these every day.
You see that?
Okay. Is effective until midnight on March. I guess that's 12/26.
Right.
So after that, are we here on things subsequent to that date?
And then, Your Honor, he was served on June 25th with the protective order of family. So now there's this order's in effect. The June 25th.
Well, I don't think I have.
That's not clear, Judge, as far as whether or not we're here on things that happened before or after that.
What are we
March
here
date.
on then? I think the state has a motion to increase the defendant's bond that was filed on June 23rd. And it states that the defendant had not had any contact. This is on June 16th. That the defendant stated he had not had any contact or communication with the victim. On that same day, the victim's mother called the district attorney's office to report he had in fact made repeated communications to her and her daughter, and stated he would take them to court to get custody if he was not allowed to see his daughter.
Not for me. I think June 16th, we were in court and the court verbally admonished him not to have any contact. So we could go from the 16th.
This state contacted the victim's mother again on June 23rd and was informed that he has been to the house where the victim and her mother lived multiple times, and told them he did not have a bond condition where he was not allowed to speak with him. Additionally, the victim's mother stated he has called her multiple times wanting to see his daughter. And then that's the state prays for the granting of a motion to increase the defendant's bond. All right. The problem with this is, because I don't know what the times, dates, or events are. It's just generic, and so the court really doesn't have any in the four corners. It's not specific enough, but it does generally allege allegations of wrongdoing, which need to be supported by more evidence than what the four corners state. But the point is what are the orders? And we're gonna, whatever the orders are that are in effect and might be superseded by other orders. What orders are in effect, but we got different orders running around from at least 3 different courts now. So mine are important to me, and the ones I give are to be followed. And if he fails to follow after the court's rendition and order goes into effect, then he's subject to.
Obviously, since June 16th and the court's oral admonishment to him and we're not having any contact, he's invited that in.
Right. So
I'll represent
what can the state say
the-
about?
Judge, I just want to be clear. So I know that paper had no contact in a threatening or harassing manner. Is the court ordering him not to have any contact with the victim or the victim's mom at all?
Yeah, okay.
That was my understanding.
Yes.
16th.
Yes,
Okay.
I want everything frozen
Okay.
until we can resolve this thing as soon as possible. But then what happens is typically is that everybody's got a different story about what the facts are. When we're not watching, and then the court's got to resolve the dispute. But the orders, we've got 3 sets of orders here about freezing the action and not having any contact. And
Well, 4 if you count the Boston.
And I don't have to remind you about what the 4 corners of the indictment state. These are very disturbing allegations. So I'm a parent, I'm a grandparent. I can't even fathom even thinking about what these allegations state. I mean, they're very disturbing if they're true. But the grand jury found enough evidence to bring an indictment. So we're going to make sure that whatever evidence they had to support their rendering of an indictment, that is enough for us to freeze the action. And until we can resolve this, I don't want you having any contact, because whatever you do can be, unless we have a jury watching you, it's he said, she said. And I get frustrated with that because that's hard to resolve. But what is easy to order is no contact, nor anyone on your behalf. And get whatever orders we need to be placed in this case until this case can get tried, need to be done. So we've got a family unit that's obviously not a unit, which I know I want a family if it can be put together. If not, then the law will dictate how that will happen. But these are very disturbing allegations. How old is the child, please?
She's turning 2 on September the 27th.
She's going to be 2 years of age.
Correct.
All right, what's the state asking for? Any other relief?
No, sir. We'll refile the motion if needed with better dates. If not, we'll just continue on to the disposition of the case.
Okay, so the orders are you can't have any contact with the child or the mother unless otherwise ordered by the court.
Understood.
Your Honor, to be clear, that's direct or through other people. You can't get other people to contact him.
I'm sorry?
It's direct and indirect. You can't get other people to contact him on his behalf.
Yeah, you think,
Just to be clear.
yeah, acting on your behalf is the same unless it's otherwise approved by the court. Trying to think we're missing something. I don't want something bad to happen here because we had a loose end. Anything else anybody can think about?
Nothing more from
Do
the
we need a
state judge.
GPS device or something on it? So we know where he is?
I'll defer to the court, Your Honor.
I would suggest that based on the circumstances surrounding the initial case, Judge, I would suggest that. And the fact that when he was asked about the contact, when he appeared in court the last time, he said no, when there was in fact some contact at some point in time.
I think.
Can you explain
I
that?
think, well.
Can you explain?
But Your Honor, I was.
Why weren't you forthright with me?
No, I was asked if I was living with them, and I said no, I wasn't living with them. And I was basically going off of the other paper that I received from whenever I got out of the county. But ever since you mentioned that, no contact, and on my work online too, I do go see people on a daily basis, and I don't know that monitor. I mean, shorts. I don't know if that's going to be looking real presentable on my end.
You know what? I couldn't care less.
I understand.
That's not my concern. You put yourself in the situation.
I understand.
Okay, well, you're gonna have to, it's not gonna be as convenient as it would have otherwise been had we not been in this situation with these allegations.
Correct.
But yeah, that's if I order a GPS, then that's your problem. You have to deal with it. We got a lot of people running around GPS in this court, out of this court, and they function. But once again, those are problems that occur that have to be dealt with, that the court has to respond to ensure that the status quo is kept until we can resolve this. If I find out about it, I don't think and one other thing that bothers me is what they're saying is in this probable cause affidavit, this occurred while you were apparently intoxicated. What about that?
I shouldn't drink or consume intoxicating substances
Yeah.
as well, Your Honor. No alcohol.
Yeah. Obviously, that may have, which is not an excuse under the law, but I see it all the time. And people, well, I was intoxicated. Unless somebody forced it down your throat, you are responsible for your actions. All right, what's the next event?
So he had refused the police, a straight probation officer. We had wanted deferred, so I've set it on the trial document, I guess. I'm not sure at this stage that I've kind of completely unagreed. I mean, I'd like him, if I'm going to do that, to establish a track record on his part that he can abide by the court's conditions while on bond. So in order to have a better argument, if I do go unagreed to the court, that you should give him deferred instead of straight or the state's injection. That's where I am with it.
Mm-hmm.
He doesn't have any criminal history. No, he has significant criminal history. He's eligible for jury probation, but of course that would be with a conviction. But the state's not offering deferred at this point.
What's up, man? You need anything? Hey, I told you.
Said if I am going to go to the court and ask for deferred, I'd like him to have a track record. He can abide by these conditions and do what's required of him. For the court to consider that, making its determination of whether he should get deferred or not.
And just to
Well,
correct,
here's the go ahead.
I'm sorry.
just to correct for the court, defense counsel just made a
Is he-
statement that he doesn't have any criminal history.
Significant criminal.
Okay,
history.
he does have a couple
Okay.
possession of controlled substance and I believe an unlawful carrying of a weapon.
No felony, no felony. That's a significant criminal history, Mr. Call.
Just a side here, why don't y'all look legally at the indictment, what it states, is under this indictment, is he eligible for regular probation in front of a jury?
That's it. Well,
I don't think so, because it says a firearm was used in the commission of the crime.
So the jury couldn't get any probation.
think so.
On 3G, I thought they could. I'll have to review that.
Well, I think that needs to get looked at.
Yeah, that changes the perspective if that's the case.
All right, let's,
I still would like to have him out for a while and then go to the court.
sorry.
I would like him to be out on bond, establish that we can abide by the court's conditions with Marlon. Attempt to get the court to get him deferred.
What else do we have? What orders are you asking right now in this court?
The GPS, the no alcohol or drugs, and the no contact.
I don't see that that's unreasonable. I'm going to order that. You got 24 hours to get all that done. Go through him. He knows how to do it. But two of those are things that are going to be your decisions in your actions. The other, you have to have a GPS device so that if there is ever an issue, yeah, I wasn't there. Yes, I was. No, yes, he was. No, he wasn't. And you know, the GPS will monitor your whereabouts. And again, no contact with the mother or the child until further orders. Anything else set? And our next event is what, trial? Is that what you want?
Well, just set for that, this one.
Sir.
Just gotta set it for now.
All right, how long?
I think it's.
What do you want? 4, 6 weeks?
6 weeks, that's fine.
6 weeks. Thank you. Okay, that is all. Daniel LeBlanc. Ready? That's all I need. That's.
City Judge, I do want to make sure the record I offered the defendant time served on a misdemeanor, and I want to make sure that's rejected before we go forward.
Okay.
He doesn't want to take conviction for them.
Just want to make sure it's on the record before we do this. Okay.
Go ahead. This is Daniel LeBlanc, 24
Yes, sir.
CR 520.
Your Honor,
The state is present and the defendant is present with his attorney, Mr. Kimmer. Go ahead.
I related an offer to the defense of time served for a misdemeanor conviction, and I understand that's been rejected. If that's been rejected, that's fine. I just want to make sure I give him one last chance before I do this.
Just to make sure the sorry terrorist is listed here.
Terrorist, yeah.
She can't.
I'm sure.
Your mom.
Oh, it's rather large.
Certainly is. He's indicted for a 3rd-degree felony, right?
Yes, sir.
Okay. Okay. That carries with it up to 10 years in prison, but he's eligible for probation if he was found guilty.
No, if you don't want to send it out.
Yeah.
No,
Yeah, he's been pleading not guilty, so.
that's what I'm saying.
Then Judge, with that, I'll withdraw all offers after that. So we're not. Let's try it.
Okay, everybody hears that. Okay, then that will be a ready here.
Yes.
Jason Altman. John West.
Madam Judge, I'm ready for trial 6.
I'm sorry,
I'll try 24-608.
that's a possession.
Yes, ma'am. He's habitual, so.
All right, Darren Patterson, Mr. Burbank.
This passage right here is the.
What do you want? You're ready?
We're ready, Judge. I only represent him on the gun charge.
Yeah.
Trying to get him, but I am number one.
Who said you were number one?
Huh?
Who said you were number one? Was that a vote that was taken?
That was a vote.
Was that people had sent in letters and
Oh,
John didn't want, John says he didn't vote.
I think I need to sit down on this one.
Which one do you represent him on? I am
He's done, Joe.
What's the, I haven't told her the gun charges. Is there priors or anything? No, there are.
I didn't hear what you said, Judge.
Are there priors on that? In
Yes,
that
sir.
indictment? What?
Oh, you said that.
How many? One enhancement?
I don't know if this is what she said.
Yes, sir, just one.
So it's a third degree enhanced to a second? And he's not eligible for probation? I guess. With the prior.
You thought for a few years. She was right.
And he knows that. Okay.
And if everything falls through, Judge, I'll be ready on that.
Okay. There's gonna be some others that are gonna be ahead of y'all, but I want to set it briefly forward, just not on advance.
Whatever date you need then.
It's 4 weeks good
Yes,
for
sir.
everybody? Okay, let's set this, try to get this tried on in 4 weeks, okay? And it's the possession of a firearm charge that the state's gonna go.
Yes, sir.
Okay.
Judge, can we find out who represents him then on the possession of a controlled substance? Or is he planning on,
I was planning on.
oh,
What do you say? He's mobile.
he's not represented on the possession of a controlled substance. He's supposed to be hiring Burbank, but he has not hired him on that other charge.
We might have come to a meeting of mine.
It's 2 years old. It's about time you hired somebody, but that's okay with you. We're gonna move forward without it. If you don't have a lawyer, you can represent yourself. You've had more than enough time to hire somebody, sir. We're gonna move forward in 4 weeks trying this thing.
That'd be fine.
Okay, the special
Yeah,
exception.
me, I'll be ready.
Aaron Trailer, John, Ware,
Yes, you're ready. You shouldn't talk about it quite a bit. Yeah.
Racolby, Washington.
Yeah, it's been or not.
Yes, sir.
They're gonna announce it, not see.
When are you gonna be able to try it?
They have about 6 weeks. I've got to take care of it.
Is he here?
Mr. Watson, I saw him in the hallway. He is here. I can grab him.
Racolby, Washington? No answer in the courtroom.
I don't mind giving Charles some time, Judge.
Okay. What are we gonna do on Patrick Winston?
Judge, I'm hired on that case and all.
Okay, hold on.
I just wanna, and he's here.
My mouth about it. He's sitting up hallway. Some sunglasses.
Well, he needs to be in here. Where is he?
He'll come through that door in just a second. I saw him.
Should we have a musical introduction?
You see him, I think so. There is Mr. Watson, you are.
Come on up. This is where the action is, sir. You gotta be in the courtroom. You're Racolby, Washington, correct? You have to speak up. And yeah, this is the way it works. We don't use sign language. You're charged with several serious crimes here, but let's get sit here. Understood which one we're gonna be going on, okay? Because you got, and we're gonna reset this, but we're gonna set it for a specific time and it'll be tried on that day.
Yes, sir.
And then we'll go to the next one. And the next one after that. 1713 is second assault of a child is second degree felony.
These all arise out of the same fact and circumstances, so I will likely try them conjunctively, Judge.
That is just, that's not a discussion. And discussions are ongoing.
Okay, so there are 3 second degree felonies which carry each one up to 20 years in prison, and then a third degree felony and 1716. That's 10 years, so you're looking at a total of potential exposure of 70 years in prison, up to 70 years in prison on all this. And y'all are going on the sexual assault child.
I'll probably go on all at the same time, Judge.
I understand.
I will file a motion to consolidate and to stack the sentences if it happens.
Same complainant.
Yes, sir.
Yes, sir.
Okay.
As I said, we have ongoing discussions about it.
Discuss all day long. We're trying the case.
Yes, sir.
What's this? We're gonna set it on a particular day from today. What's
Yes, sir.
good? Give me how many weeks?
I-
Is 6
I'm
gonna be
defer
good?
to him, Judge.
Six, okay.
Thank you, Judge.
Set it, specially set, 6 weeks. And the relationship of the child to this person is
No
no,
relationship.
because you can't have any contact with that person, nor anyone on your behalf. Let me speak, you can speak afterwards. She can't take, when both people are speaking, she can't take it. Although she can do great things, but that's impossible to do when more than one person is speaking at one time. And she has to, by law, take down everything that's said. Anyway, it would be inappropriate, plus it would be catastrophic to your bond, either through both your bond, if you find out you or someone on your behalf are trying to influence her or help communicate with her prior to this class. Understand? You know what that? Sitting there, waiting. Oh, that's a coincidence. What are we doing there?
He's here.
Okay, what are we gonna do, like,
Just, so. Mr.
are you gonna try this or?
I will, but I didn't plan on, he's right here.
Is he handling the case now?
I believe so. Probably after this time on,
Okay, you've hired him?
Yes, sir.
Okay, well,
Okay.
okay,
Yes, sir.
then you're on it. Right. Okay, 500 days old, what are we doing today?
Uh,
Y'all ready?
I was hoping you, it's not, I'll make myself.
You know, there are gonna be others tried before today, but we need something settled so that you're ready and we'll move forward on these types of cases. We don't want to delay anything longer than necessary. And how about we'll especially set it for is 6 weeks good? Perfect. We'll see where we are.
That's cool.
Latanya Bryant, get a resetting. So Latanya Bryant, that's yours.
Judge, I got, you just here for seven.
What are you doing on this?
Judge, on Latonya Bryant, as I was prepping that case last week, I had a chance to talk, I had it with Mr. Ham as well.
How'd that go?
Right.
Was that,
No, that's fine.
was that a good thing?
That's productive.
Productive. But Judge,
Disappointed I wasn't there.
oh, hey, no problem.
Fun to watch. But we want to do.
Let me tell you what I want to do.
Yeah.
What happened was with me visiting with her and preparing for this trial,
Yeah.
and I did communicate with Mr. Ham. She was hearing voices and the voices wasn't me. So out of abundance of caution, I filed a motion to have her listed for competency because and this was last week when I was talking to her. The voices start coming to her and like I said, it wasn't me talking to her. So I got kind of nervous about that. So I wanted to.
Did you hear the voices?
No, I didn't hear them.
No.
But and to my understanding,
Had to be asked.
well, hey, and to my understanding, she does have a history of mental illness.
Well, you need to look into that and
Yes.
get
that. But yeah,
something firm so we can make a ruling on it and whether
Yes,
she's
sir.
competent or not.
but I did file requesting to have Dr. Rapon at least look at it.
Yeah, I'm printing it out. Just a second.
Were you retained on this one?
Well, sir. Next one.
I see she's got some prior convictions of aggravated assault and delivery of a controlled substance and so.
Yes, sir. And I also understand from talking with Mr. Ham And another reason I want to reset it as well, in addition to getting her tested, is that I understand that there's another case that's supposed to be coming that's going to be indicted, I guess, soon. I don't know the details of all of that because they don't probably tell you about that. But
They were filed.
I do understand there's another case that's coming down the pipe.
4 wasn't enough.
No, we wanted more. There's one more coming to it.
Let's see.
It's actually scheduled to go before the grand jury this week.
We got 4 felonies, separate felonies within a span of 3 months.
Yes, sir.
And I think that.
Where is she now? In Cutting? Okay.
And just formally, Judge, the state is ready to move forward on the aggravated assault with a deadly weapon, false number 25 DCCR 0885.
Okay. Okay. Hey, Langston, your motions for an examination regarding insanity. We need to put something on the record other than just a summary. The issue has been raised. What is it about it that you can articulate, that we can put it in the record?
Yes, I can.
Because this is just, a summary, and everybody would file motions if
Yes, sir.
it was just this succinct. Because what's a problem here, among other things, is we've got this cocaine charge that comes along. After all of these, you have 4 separate events here on separate dates in just a matter of months. An aggravated assault with a deadly weapon, and 885 with 2 prior second-degree felony convictions. So that second-degree felony, the first-degree felony punishment. Then 2510, evading arrest or detention, third-degree felony with the 2 priors alleged. So that becomes a second-degree punishment. Then illegal possession of controlled substances, state jail felony with those 2 priors in sequence. So that becomes state jail felony punished as a second degree. And what did I miss? Collision, third degree punished as a second. So, and what bothers me is this was just 4 different serious felonies within just a span of about 4 months. Anyway, if you can articulate and get this to me, and then we'll
Judge,
we'll work on that. Getting Dr. Khan, and then but we're going to foresee and set it in 2 months. Okay,
no
a trial in 2 months.
Okay.
Is that going to be good for everybody here?
Yes, sir.
Thanks. So here's the motion. All right. Right, Langston. Renuka Holiday, please. Who is on that? Renuka Holiday? That's Simmons.
My understanding is, she had told me this was going to be reset based upon a vacation letter.
She filed a
It
vacation.
says this case is reset until July 6th, and then that's today. That's what I have. Where's your attorney?
Glamour.
You're mumbling. I don't understand what you just said. Speak English, please. What did you say? Where is your attorney?
I have no idea, sir.
Okay, what is your attorney's name?
Glamour,
Galmore, I believe you say.
Galmore.
Oh, Dustin Galmore.
Judge,
This is,
It's Haley Simmons, Judge.
Judge, she did file a vacation letter.
I thought Haley Simmons was your attorney.
Yes,
She is.
That's not what she just said. She just said Dustin Galmore.
but she's in that firm, Judge. That may be the misunderstanding.
Okay,
But
there's some misunderstanding, but she ought to know who her lawyer
yes,
is.
sir. She should.
She did file a vacation letter for some reason. I missed that, Judge. That should have been said.
Till when? To when?
Her vacation is complete on the 12th.
What's the next date for that? The next trial date after that, we set it. Please. Get a reset for that lady. Adrian Booker, Langston.
I'm here, Judge. He's in custody, and if we reach it, I can get ready on that.
It's ready on proposal number.
Are all of yours, let me just, are all of yours trials?
The only one that's not, I didn't want to get trials, that last one, Hakeem, Richard. If you look at that, it's at the bottom, Judge, but more particularly, I needed some more time on that one because I had 3 other cases on the trial docket. But Richard, no, I just wanted to reset on him. And he is here. He is all the way to the back next to the lady, the light lady on the wall. They right next to each other.
Adam Chavez.
Thanks, Judge.
Okay. Adam Chavez, John. Hello.
I can be ready on that. I got ready on the first 3 that I had, so.
Okay.
If
I'm just, Dominic, I'm trying to figure out what can be tried and what can be disposed of. Well, it's, I don't understand this. Everybody wants a trial out of these 40 cases. And as you know, we try more than anybody else in the country, but I can only try one at a time. Dominic Rubin,
Yes, I'm waiting for this.
you ready?
Yes,
Kevin Peterson,
Judge, that one is a little more extensive. I'm not sure who the new prosecutor is gonna be on it. If I could get,
who is on it, on Kevin Peterson for state, please?
Has you.
It was assigned to Colin. She's gone, so.
I understand.
I don't.
She's got it.
Tommy, but I've put it on Tommy's radar that I.
Where's he today? He's not around. He's clearing stuff out. It's clear as well.
Yeah, he's trying, well, he had one case left over that's specially set next door, so he's
Right.
trying that.
How much time? Y'all,
4 weeks.
4 weeks, fine.
is 4?
Yeah.
Reset 4 weeks on Patterson. Hakeem, that's Langston again. Kendra Petrie.
That's where we said.
Well, I'm always ready, but, there's a number of co-defendants.
We're gonna reset that one.
Yes, sir. There's 2 co-defendants that I need to make sure she's set with.
How long?
I think they're set in September.
Is that what we
I'll
want to
update
do?
it.
Set this, I'm resetting this from July to September? Is that what we're doing? Is that what
I think that's when those are set for, Judge.
And Robert Chason, John,
same announcement, Your Honor. I mean, I'm ready on the other ones. I mean,
all right, okay.
I'll see if I can still work it out, but I don't, but it's not.
Yeah, I'm gonna either work it out early or we try it and.
Yeah.
That's, but they can sit around and their life goes by. Here's what we're gonna do is, Mr. Ham, Lakey, are you ready on that to go?
Yes, sir.
1 and Parker, 2, John?
Yes, sir.
And LeBlanc is 3. And Altman is 4. I think. And then finally, trailer 5, I think that's all we can do. And then let me get these 2 pleas on Clark and Edmondson, okay? Langston and Marvin Lewis,
I think he's next door to the.
not surprised. Here is all of this. Thank you. Sorry, couldn't get much done. Marvin, we're ready on a plea on Edmondson, right?
No, Judge, I went over there to finalize it with him. He wanted to speak with the court. I believe he wants new counsel.
No,
So,
you didn't get new, not today. Good Lord, 1,000 days? Where is he?
he's in custody. He's in custody.
Yes, give me the file, please.
Hey, Judge, yes, I'm here. But the other one on, I was just telling him what's. That's that first case, right? Bro. Yeah, there's one. Hey, quick question for you, Judge, on Foreman. That's this case. The Leslie Court Foreman, I gave him the offer, which is 10 years. I know he's a habitual. I just wanted one reset to make him that. That's the first case you called. You just called the jail run. On that case, if you don't mind, the offer is 10. He's habitual, looking at 25 to life. I just wanted him to have just one reset to think about it, and I think he's going to end up taking it. But I don't want to put it on no trial doc. And I did give him his discovery on this too. So, but the offer is 10. And
Where is he? He's back there?
He's in the back.
Yeah, we'll bring him out in a minute, okay?
That's cool. But I just wanted to give him a little time.
Okay. We'll get Foreman out for a minute, but I need Trevon Clark.
Clark, we already did the plea.
Was it clear? I'm sorry, it's
Judge, are you sure you don't have Edmondson right next to you?
maybe
It's not this staff.
Clark. There's Jordan. And then Marvin Lewis on Edmondson. We needed him out.
Yeah.
Come on out. Jordan Edmondson, please. We're working on it. Who was the other guy we needed?
For Langston?
Yeah, Langston.
Mine is that Foreman, Kirk, whatever, yeah. I'm
Yeah, let's bring.
Oh, yeah.
You want Foreman first?
Yeah, Langston, your guy's foreman?
Yes, sir.
Okay, yeah,
He's here.
let's talk.
Foreman file, it's on the regular document.
Today is the 6th. Actually, it's on the law, sorry.
All right, we call 26 CR 293, the state of Texas versus Leslie Kurt Foreman. You're Mr. Foreman?
So,
And you were here with Mr. Adams, your attorney and the state's attorney. I'm looking at this file here. And this is an indictment charging you with failing to comply with sex offender registration, which you've only been convicted 4 or 5 other times of that. So you know that it's got ramifications. It's got requirements because you've been convicted failing to register in 2004 out of Faulkner County, Arkansas. Failing to register out of Faulkner County, Arkansas in 2009. After that 2009 conviction was final, you committed the offense, it says, of failing to register and were convicted of that felony in 2011. After that was final, you were convicted of failing to comply with sex offender registration for life and were convicted of that in 2020 out of Bowie County. You've been an habitual felon at least three convictions ago. So you're looking at 25 to life. You understand? All right. That's just so you know. And this is what this alleges is, once again, you're accused of failing to comply with sex offender registration in this county. And so you're not eligible for probation and your minimum sentence is 25 years to life. Do you understand all of that?
yes,
All right. So what else? Did you want to put something else on the record?
yeah,
Go ahead.
yeah, just the offer in the case is 10 years. He is aware that he's habitual, looking at 25 to life. He did not want to place the case on the trial docket. I think that he needed a little bit more time to digest the offer and just wanted one more announcement, but he did not want to reject the plea offer and he did not want to set it on the trial docket. I think he had some affairs that he needed to get in order. So that's what he was asking for. But I did.
Well, he doesn't work on his timetable. I mean, this thing's been indicted since February 16th.
I didn't know what the.
It's going for 5. It's 5 months old right now.
How about start 2 weeks then? Just 2.
I got 1.
1 is perfect. We can, we'll take that. 1 will be fine.
All right. You've had more than enough time to think about it. You got 1 week.
Thank you, Judge. Appreciate you. Thank you. I'll live in. Right.
Hey. For Burkett.
He's a bond hearing judge.
What's his bond man?
12,000.
What about David Desautel?
Mr. Ham and I are working on a potential resolution to that case. Jimmy, do you have a amount of time that you?
Right.
You want like 2 weeks for us to talk about it? Or?
If you give me a week to talk about it.
Reset 1 week
Sure, Judge.
on Desautel. What about Joanna Glover? Joanna's got 6 cases.
Yeah, she does, Judge. I'm talking with Miss Moore on one of hers, trying to figure out if that one's gonna be dismissed or not, and then what the direction of the others will be.
Okay,
If we could have 2 weeks on that.
you got 2 weeks. All right. And ma'am, your name, please.
Crystal Bass.
Your Crystal Bass. Okay, you've got 2 cases, Miss Bass. In 25 CL 1809 and 1810. Assault on hospital personnel and hospital property. Each of these cases on or about. Well, one was alleging on or about November 8th, 2025, that event. and the other is on or about October 14th, 2025. And then the indictment, God bless you, goes on to allege that in 2019, you were convicted out of Hardin County District Court for attempted aggravated assault. So these two charges on assault on hospital personnel are third-degree felonies. If all of this was found true in these indictments, your punishment range is a second-degree felony. You're looking at no less than 2, no more than 20 years confinement in prison. Probation is not an option because you have, according to the indictment, been previously convicted of a felony, which eliminates any probation. Look at this. And she had earlier been evaluated by Dr. Ed Griffon for the issue of competency to stand trial. And Dr. Griffon, in a letter dated June 26th of this year, a week or so ago, deemed the defendant to be competent to stand trial. In this evaluation, which the court is going to mark as Court's Exhibit 1. This day. In each of these cases.
Every single one of them is evaluated.
I don't have enough room behind. Gotta use two exhibit stickers. Okay, this is Court's Exhibit 1 for each of these cases. Part of the record and sealed except for purposes of related issues that may come up during the trial. What are we doing?
Judge, I just wanted to go over her options with her. She has a current offer from Tommy Coleman, the new prosecutor in her case. That was only good for today. He's offering a plea for 2 years, running concurrently on each case. After today, that offer will go up to 5 years. As you explained to her, you do have 2 pending third-degree felonies. You understand that, right?
You have to speak out so she
And then with that prior that you have on the record, you understand that you wouldn't be eligible for any kind of probation out of trial. Okay, and with that prior that you have on your record as well, that would also enhance you to a higher punishment range. So instead of your punishment range at trial being the third-degree felony range of 2 to 10, it would enhance to 2 to 20. You understand that? You understand that you have a current offer on the table for 2 years TDC, and then you have 140 days credit.
Yes, ma'am.
Okay, and are you wanting to accept that offer, or do you want to set your face for trial?
I'll accept the offer.
Okay,
is this a plea in each case?
yes.
To run concurrently, right? That's your understanding.
Is that what you want to do? You can set your case for trial.
Write it up.
I just need to make sure that you understand all of your options.
Write it up. That's good today.
Okay.
Thank you. All right, thank you. We get to this here. Did you say Burkett as a bond hearing? Yeah, we're gonna get to that. After.
Sure, that's fine.
Moves up stuff.
Here, have your.
We'll get to that later though. Yeah. Bridget West.
She's a plea judge.
No. Okay, that looks like it is. Right, Bridget Wedlow. You're all ready?
Yes, Judge.
Bridget Wedlow, it's on page 4. Kendall, thank you. You're doing a good job, by the way. We lost our bailiff who had been there for 100 years.
Didn't lose him, he retired.
He retired.
They're great friends.
So you don't feel like he's a loss to us, huh?
We will feel.
I see.
But
Okay, I understand what you're trying to say.
for him in his retirement.
Well,
She's jealous.
kind of said if it weren't for you, he'd have stayed. That's what he inferred.
We worked together for 15 years. He would have left
I
a
know.
long time ago, those to me.
He called that a living hell. By the way, is the way he described that.
Biggest judge. Congratulations, week one.
Congratulations. She's like top lady in court coordinator. In this profession, she's got a special degree, and also her final that she had to prepare is being published on bringing live coverage, YouTube, a case court TV to people, and because of the efforts Lacey did, she got a special honorary award for that. Yeah, she graduated first in her class. Yeah, smart lady.
Just raise your right hand.
And I think we're gonna miss Dennis. Nice guy. He was with me for the whole time,
Really?
20 years. Yeah, I guess he just got tired of me, really.
Yeah, it's not you, Lacey. He knew it was his time.
When we were in high school, he went to Beaumont French. I supported his ropes. I ran track he threw the shot and the discus, the state records for those 2 events. He was a famous guy, because he was big. He was the size he is now when he was in high school, and he was strong, man. Yeah, nicest guy. Yeah, we're gonna miss him. All right, I need a file here on Bridget. You Bridget Redmond?
Yes.
26 CR 133 is called the State of Texas versus Bridget Wedlow. That is you. Present with Ms. Manaldi, your attorney and the state's attorney. Does the defendant waive a formal reading of the indictment and the arraignment here? Can we proceed in summary?
Yes, Judge.
In summary, this indictment alleges that on or about December 2nd, 2024 in Jefferson County, Texas, you committed 3rd-degree felony of having a prohibited substance in a correctional facility, namely marijuana. You brought into the jail, Jefferson County Jail. You understand what you're charged with?
Yes.
Now, this is a 3rd-degree felony, which carries with it up to 10 years confinement in prison. And an agreement has been reached where you would be pleading guilty to the lesser included offense of illegal possession of marijuana, a Class B misdemeanor. Just want to make sure, is this going to work under this indictment?
I believe.
I don't know.
But that-
No, the indictment says intentionally and knowingly take a controlled substance, namely marijuana, into the jail is that going to be covered under illegal possession of marijuana? Under the elements? That's all I want to ask. I don't know.
I mean,
The allegation, this, we're doing a lesser included from intentionally and knowingly take a controlled substance, namely marijuana, into the Jefferson County facility. I mean, that going to match up with illegal possession of marijuana, which are the elements that we're looking at. I don't know. I don't think I've ever done system, a lesser included like this. But it might have. What do y'all think?
I'm not sure if it's gonna fit, Judge. This is,
Yeah.
Mr. Coleman did this. I'm just not sure it's gonna fit. Who was? No.
he thinks it is. I think it's hard.
See, it's under the Controlled Substances Act, isn't it? So
It's under, well, 3811 is what it's under. Prohibited substances and I was at a correctional facility. This says G. But there's a way they could have alleged it where they possessed it while they were in the jail. That would have been,
No.
that would have worked. This is
The
tape.
tape is-
Don't. I'm trying to figure where that is.
well,
3811C is tapes.
it's 3811B, isn't it?
B is for alcohol, Judge. C is for controlled substances.
Now it says takes alcoholic beverage, controlled substance, or dangerous drug into a correctional facility is subpart B.
Then C is controlled substance and also a dangerous drug.
Into property owned, used, or controlled. Prohibits a person provides or possesses with intent to provide. Okay, let's see.
I don't know if we can amend that and take it and say possess, but no, but that's a whole different section. The taking would be, you have to possess it to take it.
That's my argument.
Point, Your Honor. I'm the one that created this situation, Judge. I apologize, I'm out of breath. I was upstairs working on a trial. So I took the stairs down. Judge, if you don't believe it is, I was watching on YouTube. If you don't believe it's a true lesser included, I would suggest that we do an oral amendment.
No, I question it. It's just.
I would.
We don't want to pay for the same real estate twice,
Sure.
so.
Well, could we do an oral amendment to the indictment, Judge?
See, this one is a bar exam question because the indictment alleges a crime under 3811. The person commits an offense if the person provides or possesses with intent to provide, I'm sorry. C, subpart C. A person commits an offense if the person takes a controlled substance on property owned, used, or controlled by a correctional facility, and into
What's that?
and I would think into the facility is on property owned, used, or controlled.
Judge.
So
Just my 2 cents on that, coming from a C- lawyer. I would just say that to
You-
take something into, to take something into.
Who are you talking to? Which one of the lawyers are you talking about now?
Myself.
Oh, my.
To take a controlled substance into a facility necessarily implies that you possessed it to take it, Judge. But I think we can cure.
But it's under subpart B under section 3811, and you're stating section 3811G.
I think we can cure any questions, Judge, if we just do an oral amendment. If defense counsel is not opposed to us doing an oral amendment to the indictment, and I think we can cure also.
So now we've got either can't prove witness or something else.
Yeah.
Fingers in my ears.
Why not? I think that could work.
We're fine with that, Judge. It's the same resolution
And-
to us, for us regardless. She's.
What you're doing is, it's, you're bumping it to a misdemeanor that
Whatever, however.
the DA's office, the executive branch of government would be controlling, not the grand jury. And this is word for word a crime under under subpart B under section 3811. A person commits an offense if the person takes a controlled substance into a correctional facility. And that's what it's alleging, word for word, and that's subpart B under section 3811. And this indictment is captioned section 3811 subpart G, which is just the offense.
Well, the caption, as the court's aware, is not substantive. Or controlling.
It's obvious what the grand jury intended, that it fall under that statute. And
We'd like to just orally amend the indictment, Judge,
to
possessing as opposed to taking, possessing in a correctional facility, or just strike the rest of that correctional facility altogether and just possessing marijuana, and then strike the rest of that after marijuana, Judge. To intentionally, knowingly possess a controlled substance, namely marijuana, and just strike the rest of that, Judge. And I don't think defense counsel would be opposed to having the objection to that.
And then that would be the same result of giving to the lesser.
And anything above the quote unquote line, as far as the caption, is not controlled, Judge. As far as the statute that's cited above the lines in the indictment.
But, okay, so then what you're doing now is going under the Controlled Substances Act, not under the penal codes.
Yes, sir.
But, just seems like that statute is word for word under that section that was indicted is word for word under subpart B, which ought to be enough. I mean, it's the same statute to be proper lesser included.
How are the court seats get to her?
However you prefer, Judge. I mean,
Yeah.
either way, she's not having to plead to the indictment. It's still the lesser.
Yes, sir.
Okay, we're gonna change this to 3811 subpart B.
Yes, sir.
Without objection.
Correct. Not from the state, Judge.
Small case B.
You already grabbed it. I mean, I'm not going to.
And then this is a class A misdemeanor, everybody? Oh, class B misdemeanor.
The intent was the B. Yes, yes, sir.
Well, the problem is there isn't a class B misdemeanor under that statute, under that section. So we're not, it's not or lesser included under there. I think what y'all need to do is file information on a class B under the Controlled Substances Act. Because I think it's a landmine waiting to be. I mean, y'all aren't going to do anything, but somebody later on, somebody could challenge it. I think it's an issue.
Even with an oral amendment to track the statute under the Controlled Substance Act, Judge.
Well, you're now going under a charging instrument you're not working off the indictment from the grand jury. If there was something under this indictment that we could do, but it's.
Oh, one other thing, Judge, and I don't mean to be the dead horse. We'll let this go after this, after I make this pitch to the court. What if we do the 3811? Was it B that you were thinking? And because it does not.
Yeah, that's right. But there is not.
There's no misdemeanor there, but what if we did an attempted under that one? Would that get us to a misdemeanor?
That would get us to a state jail.
Okay.
30 degrees.
And then with state jail, could we punish it as a misdemeanor, Judge?
You can use
That would give.
44B if you want to.
Yeah, I'm just trying to move the case, Judge. I'm all about moving cases.
That 44B, Tommy, give misdemeanor conviction.
Yeah.
See, we're working on 3811 and it doesn't fit.
Yes, sir.
The punishment range that the statute sets forth is too high.
We can do an information, Judge. I just.
We're just trying to do it.
Yeah, she's got 132. She's got 132 days jail credit, and under the facts, under the circumstances,
What we can do.
it is not.
Could you get an information done today and then we'll bring it tomorrow morning and then.
I don't know the answer to that.
I know you're busy, but we could bring her just as soon as an information is ready.
Yes, sir. This is not the kind of crime of the century, judges.
Oh, no, but it's still, we're dotting the i's, crossing the
Yes,
t's. It's still important.
It is.
And it's a misdemeanors have their place.
Yes, sir.
According to the legislature. But the quicker you can get it done, we can come in and so she doesn't have to. And it's for time served, right?
Yes, sir.
Is that what y'all are trying to do?
That's
Get
what we're
her
trying to do. She's got 132 days jail credit, Judge, and under the circumstances, I think she's.
Here's what
I think that's justice.
Here's what's her bond right now? We gotta get it done just right under the crossing the i's, crossing the t's, dotting the i's, which may take more than a couple of days. Where's your home, ma'am? Where's your home?
I stay in Houston.
All right, if I give you a personal recognizance bond so she can be released, any objection to that?
No, Judge.
You're gonna have to report. If you fail to report, the deals are off. We're gonna have to report back here for a plea. And we're gonna set it for, you need to be back up here, because I'm gonna release you on a personal recognizance bond, so you don't have to post a bond anymore. But you have to report back. Can we get this done in 2 or 3 days?
Yes, Judge.
I'm here Thursday, so we can.
Set it for Thursday. On the docket, you have to be here by order of this court at 9 o'clock, okay? We're gonna give you,
The other misdemeanors that I haven't.
I don't know what you're talking about now. I'm just talking about this case. That's all I know about. I don't know what you have otherwise. I'm talking about disposing of this case. And then you come in, you plead, time served, and then they would put you into I think they have to check you into the jail and then you get released and you've done your time. But we would take care of this case. I don't know what your other cases are. That's not in my court. You've got to figure those out. I'm just talking about disposing of this one. Here.
If I stay incarcerated though, they'll call me out.
They'll bring you back Thursday if you stay, yeah.
We said this for Thursday at 9:00. Then I'm going to set a personal recognizance if she can make it. If she can't, we'll, because of the other bonds that she has to, or the other holds, but we'll dispose of this case on Thursday and you'll get time served. And then that will be finished, completed, and then you can not worry about this one. But be here on Thursday, one way or the other. Okay, if you're released, you have to be here at 9. If not, you'll be brought in here at 9. Okay.
Thank you, Judge.
Thanks, Greg. What I just saw.
Judge, did you? Now, did you want to see Mr. Eggleston with Mr. Lewis?
Okay, Morgan, come on up. What are we doing on this?
This is the one that we thought we had a plea worked out, but Ms. Eggleston has informed me that he wants to release me and his family hire a new attorney.
Okay. Where is it? Yeah. No way. You can hire, but here's what we're doing. It was this was set for trial. It's 1,000 days old. Sorry. And it's a murder case. We're not going to wait until the last minute and try to manipulate the court. This was set for a plea. That's fine. If you don't want to plead, plead. If you don't plead, that's okay. It's for trial. So we'll try this case first today. All right.
Judge, I was under the impression that it was going to be a plea. I need time to go and make sure my witnesses are available for today.
Yeah.
Okay.
That's not your fault. That's manipulating that I don't like. But there are no deals. We'll try this case first. Okay, that's what we will do. It's set one, I think set number 1 at 1:30. Next is who else has a? Joe, Scott, come on up. Who is it?
Mr. Simpson. It's a bond. Judge. It's in custody. Obviously.
A normal drive home turned into a nightmare when 6 gunshots were fired on a busy Texas highway. Now, months later, a jury sat quietly inside a courtroom as prosecutors prepared to explain why they believed the man sitting at the defense table was responsible for a shooting that nearly became a murder case. The trial began with the defendant standing before the jury as the indictment was read aloud. Prosecutors accused him of aggravated assault with a deadly weapon, alleging that while driving on a public roadway, he knowingly fired a handgun into another moving vehicle. According to the indictment, one of those bullets struck the victim, causing serious bodily injury. When the judge asked how he pleaded, the defendant answered with 2 simple words: not guilty. With that, the trial officially began, and 12 jurors prepared to hear 2 completely different versions of what happened that day. The prosecutor's opening statement immediately captured the courtroom's attention. He told the jury that this case was about a miracle. According to the state, the victim, Hunter Freeman, should not have survived. Prosecutors claimed that during a road rage confrontation, a bullet entered the victim's face near his mouth, traveled through his cheek, and exited just below his ear, missing vital organs by only inches. They described his survival as nothing short of miraculous. But the prosecutor said there was another hero in the story as well. A passing driver witnessed the aftermath, stopped to help the wounded victim, called 911, comforted him while he bled on the roadside, and even contacted his mother before emergency crews arrived. Prosecutors called this stranger the angel in the case, someone whose actions helped save a life during one terrifying afternoon. The state then focused its attention on the defendant. Prosecutors alleged that the shooting started with a road rage dispute after